take just a moment. We are live and recording. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations, within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. Welcome to the Appeals Court. I am Justice Rubin. I am joined today by two wonderful colleagues, Justice Blake and Justice Lemire. We will be hearing 5 cases this morning. We are hearing argument by teleconference due to the ongoing pandemic. The rules are the same as they are in our courtroom during live argument, 15 minutes per side, and we have no rebuttal. The first case we will hear this morning is number 20-408, Commonwealth versus RICARDI, and we will hear first from Attorney Schneiderman.
Actually, Your Honor, I'm in Kelly this morning.
Oh, I see. Of course you are. I'm so sorry.
It's quite all right, Your Honor.
We will hear. Let's hear from appellant first, then we will hear from Attorney Kohler.
Thank you very much, Your Honor. May it please the court, Carrie Kohler for the Commonwealth. Your Honor, the Commonwealth's application for complaint was legally sufficient and established probable cause that the defendant, Agnes RICARDI, abandoned her child by going, oh, I see my time has started. I apologize for starting early.
No, it's not you. It's not your fault.
Thank you. Where the application for complaint demonstrated that the defendant left the Commonwealth of Massachusetts, passed through the state of Vermont, and fled to Canada. Under the statute, not only did she leave the Commonwealth and enter another state, she alternatively left with no intention to return. The application for complaint, authored by Officer Post of the Chicopee Police Department, established that Ms. RICARDI left her home where she had resided for a number of years, her city where she worked, took clothing with her.
Attorney Kohler, if I could interrupt you, all that being said, I think that for me anyway, what the case comes down to is looking at the Chicopee police officer's report. There is at least a reference that the child was in, quote, foster care, and that can mean many things. Is there anything, because we are bound obviously by the 4 corners of the documents?
Oh, we have had some technical difficulties.
Is there anything that explains legally what at that time?
You're cutting in and out, Justice Blake. Maybe you want to say your question again?
Sure. Attorney Kohler, can you hear me?
I can, Your Honor, yes.
Okay, I'll try again. I apologize. I'm trying to figure out what it means in the police report, or what we would, again, just by the 4 corners of the complaint and at the attachments, what it means that the child was, quote, in foster care at this time.
That's a very fair question, Your Honor, and I do think that's the key challenge of this particular complaint application. I think Her Honor in the trial court also grappled with that question. I think that the record before you is ambiguous at best, and I know that the transcripts are before you, and I'm sure you're familiar with those, and I think that was a question that the parties grappled with. And I think that with respect to whether the child was in foster care, it doesn't matter for the abandonment analysis. And I think to answer your actual question is what does foster care mean within Officer Post's police report? I don't think we know. I don't think we know what that means.
So are you entitled to the benefit of that ambiguity, or is the defendant entitled to the benefit of that ambiguity?
I think under Newton N, the Commonwealth is entitled to the benefit of that ambiguity. And I also think what's interesting about the abandonment statute and the subsections under 273 is that the legislature recognized there might be situations where there is an obligation to support a child and the subject of that obligation doesn't have custody of the child for whatever reason. And I know that my brother differs with the Commonwealth's interpretation of the obligation on the defendant in this case, we're in a criminal context. But the legislature's reckoned that doesn't excuse.
Well, let me ask you, in the civil context, in the probate and family court and in the juvenile court, the department can have physical and legal custody of the child, but the biological parents are still required to provide financial support. That's in the civil context. Why or why not should we apply that legal premise in a criminal case, which has a very different burden of proof?
I think that's a fair question. I think that the two most helpful cases I found in the criminal context exclusively were Neville, interestingly, which is where the Commonwealth loses. But I think what's interesting about this fact pattern is it's that ultimate case of there's evidence that the defendant really wasn't going to come back. She had left the nation and taken items that demonstrated she wasn't coming home. She had her other children. I think we can make a reasonable inference on the four corners of the police report. Her husband was with her.
Excuse me, we have cases in the DCF context all the time where a child is in foster care and the parent vanishes. Are they all subject to prosecution under this statute?
I think they could be. And I think what's interesting in just reading the plain text of the surrounding sections of 1 and 7 and 15A, which are kind of like the criminal pieces, the legislature very explicitly says that a civil action taken by a probate and family judge or a juvenile court judge regarding monies and
I'm asking about in the absence of a support order.
Right.
No order like that at all. A child is taken from a family or taken from parents and put in foster care. Routinely, we have cases where no one has seen the father again. And you're saying that he has committed the crime of abandoning his child without providing support despite the absence of any order of support. Is that right?
I think so. I think the intent of this law is very clear.
How long has this law been on the books?
I don't know when it was enacted.
Have you ever seen a prosecution under this law for that fact pattern without an order of child custody payment?
I don't think
child support payment, excuse me.
The criminal cases that I cited in my brief don't speak about the prosecution of the case in terms of a court order that I recall. Neville, Trusinski, that I can and recollect are really about whether the parent is physically present or not present. They're actually, I recall Trusinski.
These are cases where DCF had physical custody of the children.
It isn't always clear. Neville,
you have a case where it is clear, yeah.
No, I don't recall that. It's more in the context of, as my brother says in his brief, the so-called abandoned spouse. And I think that's just the shape of the litigation that happened historically.
Well, calling it the shape of the litigation, you're a prosecutor, you can prosecute who you like if they violate the law.
Yes, and I think that's...
And if you're telling me this law has been on the books, and of course it started with a version, I suppose, about wives and so on. So it's probably 100 years old or more. And you're telling me you have no case in which a child who was in the physical custody of the state and whose parents disappeared has ever been, at least no appellate decision, ever been charged with this crime before. And yet you say that there are these in not virtually every, but many of the DCF cases that we have. In fact, the father is likely guilty of this crime. That just raises some questions for me.
I don't know if that's not the fact pattern or it simply wasn't addressed. I don't think the cases
I'm
are.
saying you've never prosecuted anyone for it, and neither have any of your predecessors for over 100 years. And now you're coming in and saying, oh yeah, we had care of the child and were feeding her and she was sheltered and da-da-da, and her parents left the country. Arrest them. And that seems a little tricky. Now, there were 2 charges here though, right? What was the second
Yes.
one?
Reckless endangerment of a
And
child.
there's no question about that one. That is, I mean, reckless endangerment is is routinely used in service. It's just very odd that suddenly after 100 years, you're saying that this is what this statute means to me.
I don't think that the fact that the Commonwealth hasn't utilized this law to prosecute doesn't mean that the law is any less valid. I
No,
think
it doesn't,
that
but it might tell us something about what the scope of the law actually is, that no one's ever thought to do this until someone brought this before this, whoever it was, magistrate or I don't remember the exact.
Yes, it's a district court complaint.
Yeah.
I don't think the fact that it's never been exercised means that the scope of the law is narrow. I think we've just had a limited
I mean,
quality of case.
it's a criminal statute.
Yes.
I mean, right, there's a bunch of doctrines about not, about construing it. There's doctrines of lenity and so on. I don't know if it's ambiguous, but, and so on, right?
Right. And I don't think it's a constitutional challenge. I think it just comes down to the executive exercising its prosecutorial discretion. And I think that it's a happy coincidence that parents don't often leave the country when they have to take care of their children.
The law isn't about leaving the country. The law is about leaving the state.
It is. But I think leaving
parents routinely leave the state instead of caring for their children. I'm not in favor of it. I'm just not sure this is the criminal statute that gets to it.
I don't think there's any statute that more clearly addresses that leaving the Commonwealth without making provisions for the reasonable care of your children.
You have to make the provisions yourself. That is, if your child's been taken away and is being provided for.
I don't think the defendant in that context gets to throw up her hands and say, well, DCF's got it.
Never mind throwing up her hands. Let's say she simply leaves the state. She does nothing. She doesn't arrange anything. She does nothing. Her child is in a foster care placement after an adjudication of temporary unfitness or something.
Right.
And the child is in foster care. There is no order of child support. And now the mother, without custody of the child, makes no arrangements and goes to Vermont. Maybe they come back. They're going to come back in a few months. Maybe not. We don't know. They go for an indefinite duration to New Hampshire or Vermont. You think that they've violated this statute?
Yes.
You
yes,
do?
I think they have. I think they can be both criminally prosecuted.
What's the maximum penalty? What's the maximum penalty?
There are 2 discrete for the leaving, and I can't recall them right now. One is for a 5-year state prison, and one is for 10 years. Your child is in
foster care with somebody else.
Mm-hmm.
You didn't arrange it. It was ordered by a court. And you leave the state, you're subject to a 5-year prison sentence. Does that sound right?
Yes. Yes. I think that the law and the Commonwealth and the legislature have a distinct interest in caring for a child. And I think that the consequence, what we see in this particular case, that DCF has to take care of a child, is exactly what the legislature wants to avoid happening. And I think the
child
penalty
is already in, I don't know if you're understanding my hypothetical. The child is already in DCF care. I understand if you leave town and your child is alone at home, smoking cigarettes and running out of money for pizza, you've abandoned them. And if DCF has to take them, that seems to violate the statute to me. I'm talking about where the child is already being cared for, albeit in a foster placement. You think that makes no difference?
No.
Okay.
Attorney Cole, I do have a couple of questions. I know your time is getting short. You said there were 2 cases, Neville, and what was the other case?
It's Truzinski. I cited it in my brief. It's the TRUZINSKI. And that's a case really on, I think, kind of the barest evidence the Commonwealth can present, where a single witness essentially said, I didn't get any money from the defendant for 6 months. And
so there are three cases out of the SJC. One goes back to 1908, 1929, and 1935. And those seem to be really the last three times that this particular statute was applied in the criminal context. And I guess what I'm trying to understand here, at Record Appendix 9, there's a statement by the police officer that DCF then took emergency custody after all these events happened. So I guess I have to ask you to go back to the question of foster care. In Justice Rubin's hypotheticals, I'm presuming in his questions that DCF had lawful, legal, or physical custody of the child. Here, I'm still trying to figure out what the police officer, what the clerk magistrate would have known, or what reasonable inferences the magistrate could have drawn from the fact that the child was, quote, in foster care, and then on the next page, and now DCF is taking emergency custody. I'm not sure what to do with that.
I know, and it's a really hard question because the record isn't clear. I think it, and somebody, you know, with your background or someone who's experienced would understand it. It probably seems like voluntary services, kind of, but you're reading into it. And I don't think, and I'm kind of confident in this, that there was any order of any kind of custody. I don't think the department had physical custody. I think the child just wouldn't come home, and the family accepted that she could stay in the placement that she was at.
Who gave her that placement?
The girl did. The girl ran away and refused to go home.
Yes, but the house she was in, what house was that?
Foster care?
Yes.
We don't know. And I also think, I know my time's expired.
No,
I'm sorry.
it's okay. You can answer.
Thank you. I also think that a little bit in my reply brief, I addressed it as well. I don't think the police officer understood it very well. And I think you can read that into when he goes to the DCF social worker and says, I need a timeline. I don't think the police officer understood exactly how it was that the girl ended up at the placement. I think Justice Lemire is entirely accurate. I think the girl decided she was going to stay there.
Okay, but DCF put her in the house. They had to have some legal authority for that.
That's not on the record, though.
Yeah,
well,
I don't
foster
think we know.
care isn't something one can voluntarily walk into. You can stay at your friend's house, of course. I mean, you shouldn't, you're a minor, but I get that. As a practical matter, you may run away and go to someone's house, but we wouldn't call that foster care, would we?
No, and I think that's why Detective Post called it foster care. I don't think he knew what else to call it, but I think that on this record, there's not legal significance to it. And I think that's a confusion that under the law gets resolved in favor of the Commonwealth. And we come back to, is there probable cause that the defendant left without making provisions? And I think we stopped it.
But either way, whether it was a court ordered or the child arranged to stay with some other family on her own, the family knew she was being taken care of when they left.
They do. I'm not running away from that argument. I think that's accurate. She wasn't left somewhere,
Wasn't left fending for herself.
No.
Justice Rubin, could I ask one more question? I know the time is expired.
Of course.
In your reply brief, you suggest, Attorney Cole, that this is more of a technical question. Odell has never been applied in the district court context, but you're not suggesting that it's not you're not suggesting it's improper to file a motion to dismiss based on a lack of probable cause, are you?
No.
Okay.
No, I'm not.
Okay. Thank you.
Okay, thank you. Your time has expired. And if you need an extra minute, Mr. Schneiderman at the end, we'll give you that to be fair. And we will hear from you now.
Thank you, Your Honors. May it please the court, I am Joseph Schneiderman. I represent Agnes Riccardi. I actually would like to start kind of where we left off, which is, although this court has not said there is an Odell challenge in the district court in Commonwealth versus Tripolone, this court did recognize that challenges to the integrity of the complaint process in the district court were viable, and Tripolone is in 44 Mass App. Before I get to the rest of my argument, I actually would like to address some other questions which Your Honors had. First, to Justice Rubin's question, this statute dates to 1911, and it created 3 offenses in 1911 and in 1913. And as Your Honor was suggesting, it goes to absent fathers, or as is suggested at page 13 into 14 of the brief, neglecting a spouse, impregnating a woman out of wedlock, which later was held unconstitutional in 1975. So this reaches 3 very different criminal offenses. And I would note the Commonwealth's theory here is not that Mrs. Riccardi has defied a support order from the probate and family court or from the district court or wherever. The Commonwealth's theory is she refused to comply with this multidisciplinary team interview and thereafter left the Commonwealth, and that is abandonment without support. That actually takes me to the heart of my argument, which is the legal definition of abandonment is very narrow, as has been interpreted in Niebel and in West, Posey. All of those cases demonstrate that abandonment is very contextually
those are not constructions of this statute, are they?
No, they aren't, Your Honor, but this court construes related statutes on the same subject to constitute a harmonious whole. I think Niebel is the closest example, though, because Niebel is a criminal offense of abandonment, Chapter 119, Section 39, I believe. So I would suggest, though, to Your Honors that the definition of abandonment should be construed harmoniously, both in the child welfare context and in the criminal context, in light of the odds at stake. The child welfare context is concerned with, as Justice Rubin has been pointing out throughout argument, parents and their right to care, custody, and control of their child, and must also consider the context that the Department of Children and Families is subject to a state and federal mandate to, whenever possible, spur reunification of parents and children. In this
let me stop you though right there, Mr. Schneiderman.
Sure.
If you look at Record 9, it says that after this course of events occurred, after they determined that mom was gone, the department then took emergency custody. So what was the child's status in, quote, foster care prior to mom leaving?
Your Honor, on January 2, MR, the child, ran away. On
Right.
January 5, MR turned herself in. On January 7th, MR voluntarily placed herself into foster care.
I'm sorry, I don't understand what that means. Turned herself into whom?
Turned herself in, Your Honor. I don't think I cannot recall that the complaint containing more information as to who, but MR went.
And what do you mean voluntarily put herself in foster care?
Oh, I'm sorry, Your Honor. By statute, a child or a parent may voluntarily seek services from the department and indeed may elect to go into foster care. That's Chapter 119, Section 23.
And how can a minor child consent to that? I don't understand. They just show up and say, listen, put me in foster care?
Well, then they have to, then the department has to go to court.
Okay. So did the
How
department?
old was this child at the time, Mr. Schneiderman?
16, Your Honor.
Right. So I think children over 16 can request services, but even if that's true, if R9 tells us that the department didn't have any legal custody or emergency custody until after these series of events, how do we, again, we're talking about probable cause. We're not talking about proof beyond a reasonable doubt. So what do we do about that ambiguity of the child is in, quote, foster care?
Your Honor, I think that ambiguity actually, although the four corners of the complaint must be construed in the light most favorable to the Commonwealth, that ambiguity must favor the defendant. And that harkens to my second point in my brief, which is that Detective Post created a recklessly misleading narrative, in as much as that gap may have suggested to the clerk magistrate that the Ricardis were letting MR fend for herself.
Well, I mean, no disrespect to the police officer, right? But if the five of us can't figure out what this foster care situation was, do you really think that from this narrative of Officer Post, he was trying to mislead? Or was he simply just as confused as at least I am right now?
Your Honor, I agree. I don't wish to publicly fault Detective Post. The standard, though, for purposes of Odell is not necessarily one of knowledge. It can be one of recklessness. So Detective Post,
But it's
even
reckless, but doesn't Odell require it to be done with the
Intent.
intention to obtain a charge? In other words, it was done deliberately to obtain the charge, to either mislead or to leave information out. And its purpose was to obtain the charge under Odell.
Yes, Your Honor, that's correct. Yes, that's the Odell standard. I think.
So if it's just confusion, then are you saying that goes toward an intention to mislead, to just obtain?
No, Your Honor, I apologize if I've overstated that. I think the sum of the narrative, the sum of the four corners of the complaint could have left the magistrate with the wrong impression. And in that light, because there is this key omission, there is a challenge to the validity of the complaint, particularly where Detective Post ends by saying, I'm seeking this complaint because the Ricardis did not cooperate with the MDT interview and left the country. I apologize if that was not clear.
Let me ask you this, to go to your first argument, not your second one.
Mm-hmm.
If the burden is on the Commonwealth to show probable cause, and if we know of no way you can get into something called foster care without a court order for a minor, there is no voluntary way to go be in foster care except go volunteer and get an emergency order from a court allowing it. Isn't it even more probable than not that there was a court order and that she was in temporary foster care? And doesn't that undermine the possibility of showing more, whatever, by showing probable cause that she wasn't, if that's the question? And again, I know both Justice Lemire and Justice Blake, from sort of different angles, have suggested maybe that doesn't matter. And of course, your sister says it doesn't matter. But if the question is someone who's in foster care, you aren't abandoning them in the absence of an order of support if you leave. If that's the question, isn't it a failure to get to probable cause? Maybe there's some suspicion that she's, not in foster care because of what's on page 9, but it does say foster care. I'm asking the relationship between this ambiguity and whether the burden, whether that eliminates the possibility of getting all the way to probable cause or not.
Your Honor, I think given that it is the Commonwealth's burden to demonstrate probable cause, I think this ambiguity about how and whether or what MR's legal status was qua DCF does matter. And in the absence of that, of something more, the Commonwealth has not met their burden to show probable cause, particularly in light of Your Honor's articulated concerns, the penalty attached to the statute, the narrow definition of abandonment, the fact that abandonment is one puzzle piece in a big jigsaw puzzle of not only this criminal statute, but of the child welfare system more generally. I think that absence is a key one and does not rise to show probable cause.
But why doesn't the four corners establish probable cause for abandonment? And the other inquiries that we're all having now go toward the proof of the complaint. So in other words, the officers presented evidence that the family has left the child, and at least on the record before the court, there was no record of a court order that the child was in anyone's custody. And on that record, why wouldn't that be sufficient probable cause? And the issues that we're now discussing be as relative to the proof of the complaint at trial?
Your Honor, I have two responses. First, I go back to the legal definition of abandonment, which is narrow. I appreciate that we're at the probable cause stage and the burden is significantly lighter than it is at the beyond a reasonable doubt stage. However, abandonment is construed narrowly, and I think a contrary construction, which the Commonwealth was advocating for, would be at odds with two key principles, which are: one, DCF has the mandate to spur reunification between children and families unless it's unworkable or unless there are the enumerated exceptions I've spoken about before. I think the crux of this,
according to the probable cause complaint, DCF didn't come in until after they had left. So, I mean, I don't know why we're discussing DCF at this stage of probable cause.
Your Honor, actually, I'm sorry.
The only information the clerk or the judge had was DCF came in after the apparent abandonment.
Your Honor, that's actually not quite correct. I apologize if this was not clear. DCF had been actively involved in the RICARDI's life before MR ran away. That is contained in the application for the complaint.
As far as like custody and emergency action, they didn't take over until after the abandonment had occurred. They were investigating accusations of sexual exploitation and some in-home issues, but they were not in custody of that child, according to the probable cause, until after the abandonment, so-called abandonment, arose. I'm just trying to say probable cause is one issue, proof is another issue. And I think the government has probably a lot of, just because of this discussion, has a lot of issues on, it wouldn't be a great complaint if it issued. However, does that stop it from issuing?
Actually, Your Honor, I think it does stop it from issuing, because of the court not only has to read the complaint holistically, the court has to consider the definition of abandonment holistically in light of the related statutes in the child welfare schema.
Well,
and I think
I want to go through a timeline with you in that on record 8, it says that the child had most recently run away on January 2nd, and she was located in a shelter on January 5th. But here's where sort of the internal inconsistencies in the complaint are. At record 14, it says that the father reported he learned from the police that the child, quote, turned herself in and was placed in foster care. The complaint then goes on to say DCF researched this and confirmed that the child is, quote, in a foster home, not foster care, foster home at that time, because she reported not feeling safe at home and did not want to return at that time. Those are the two times the word foster is used in the entire packet that makes up the complaint. And so I guess I'm going to go back to the first question that I asked your sister. If you can just take the premise that there's an ambiguity in these documents. She says, Newton, she gets the benefit of that ambiguity. You say you get the benefit. What case says that you get the benefit of that ambiguity?
Your Honor, I think Newton is distinguishable because Newton goes to the issue of whether a complaint has affirmative defenses. So I don't think Newton applies here. I think my premise is,
so why is the scale tipped to you if there's ambiguity in the complaint?
Your Honor, I think the scale tips to me because if a conviction cannot rest on speculation or surmise or requires mental gymnastics, so too probable cause should not also rest on that. I don't think this court or the SJC has ever explicitly said as much, but I think the logic, there is a logical analogy here, Your Honor. I see I'm running out of time. I know, Your Honor, Justice Rubin had said I could have another minute. I appreciate that. I would just end by suggesting upholding this complaint would ultimately cause more problems than it solves, because parents would be placed into a potentially untenable choice of cooperating with DCF and potentially incriminating themselves, or not cooperating and facing a charge, as Justice Rubin has pointed out to my sister, of abandonment. Unless Your Honors have further questions, I thank you kindly for your time, and I ask that this court affirm.
Seeing no further questions, thank you both for excellent arguments. It's an interesting case, and it is submitted.
Thank you, Your
Thank you.
Honors.
We are live and recording.
Okay. Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin, and I am joined today by Justices Blake and Lemire. The next case we'll hear is number 18-1192, Commonwealth versus NABABI. The rules for argument, which we're doing remotely due to the ongoing pandemic, are the same as those in our courtroom. 15 minutes per side, and there is no rebuttal. And we will hear first from Attorney Fund.
Thank you, Your Honor. Thank you, Your Honors. May it please the court. I'm Joan Fund. I represent Gloria NABABI. Gloria NABABI has 3 children, 2 of which have spent most of their life, or all of their life basically, in Uganda. Ms. NABABI brought them to the United States in approximately 2011 and to live with herself and her boyfriend, Richard KYAMBADDE. She has a 3rd child who was born in, I believe, 2013. The Commonwealth brought really 10 charges against Ms. NABABI. She was convicted of 3 counts of reckless endangerment of the children and 2 counts of assault and battery on under 14 on the 2 older girls. I would submit to the court that the Commonwealth brought the theory of reckless endangerment on the children on 3 theories: the alleged beating of the children, allegations of eating moldy food, and allegations of leaving the youngest child alone. I would submit to the court that the Commonwealth, that there is insufficient evidence to sustain the convictions of reckless endangerment of the child. Certainly, the court is aware under 265 section 13L, the Commonwealth must prove that the child is under age of 18, which of course they did, and substantial bodily injury or sexual abuse. This is not a case of sexual abuse, so we're talking about substantial risk of bodily injury. And that the defendant wantonly or recklessly engaged in conduct that created the substantial risk or failed to take reasonable steps to alleviate that risk. And that's under Commonwealth versus Cogswell in the Hardy case. Also, the statute is clear that the court must conclude that the defendant was actually aware of the risk. Section 13L doesn't identify or define the words of substantial risk, but in doing, in looking at those cases, it does talk about a substantial risk more than a possibility. And the substantial risk must be considered in conjunction with the degree of harm of serious bodily injury. In looking at serious bodily injury, this issue must be substantially more than just negligence. Courts have defined the idea of what is meant by wanton and reckless conduct, and they do this oftentimes in conjunction with manslaughter cases. And in defining them, or in presenting different examples of same, they talk about cases in where the defendant went on a high-speed chase with the child, a 3-year-old in the car. And then when the defendant fled on foot, he took the child and he knew that the child would be in substantial risk. or failure to provide medical care to a child, or where the defendant saw, say, teenagers consuming alcohol in his house, the minor is vomiting and consuming large alcohol, and didn't see the victim's request to be taken to the hospital. And those type of cases, I submit to the court, are serious in terms of defining what it would be like to suffer substantial bodily injury. And I would submit to the court that the injuries or the allegations in this case do not rise to the level. Certainly, serious bodily injury is defined under the model jury instructions. And the model jury instructions provided by the court talk about the serious bodily injury, which results in permanent disfigurement, protracted loss, impairment of bodily function, limb or organ, or substantial risk of death. And I would submit to the court, none of those things were presented to a jury. Temporary or mild.
Well, Ms. Fund, they don't have to prove injury, just the risk of injury, correct?
That's correct, Your Honor.
And here we have what appears to be some progressiveness of a beating pattern. First with a switch over the clothes, and then at some point the children are naked, and then the switch becomes a heftier stick, and then tying of them to avoid them running away. I mean, there's a cumulative effect here of seeing beating going from something being swatted over the clothes to naked with a heftier stick and tied up, ongoing. We don't have to show that there was actual substantial injury, just the risk of it. And you're suggesting that fact pattern does not show that, or is not sufficient evidence of that?
I am, Your Honor. Looking at even worse, the worst scenario that was presented to the court in terms of talking about individuals that saw either red marks on the children's body, I would submit to the court they saw them in areas that certainly did not impact any kind of loss or impairment or bodily function, limb or organ. And the other part of this, other problem of this case is that we're talking about Gloria NABABI and we're talking about Richard KYAMBADDE, and the difference between the two. Because in terms of Ms. NABABI, as the court would see in the transcripts, she worked. She worked Monday through Friday. She worked from 11 a.m. to 2 p.m., 3 p.m. to 11:30. She worked every other weekend. So it's difficult to even distinguish what we're talking about in terms of the actions of Ms. NABABI and the actions of Mr. KYAMBADDE, and whether my client or Ms. NABABI would have been aware of what those particular risks were or the injuries. But in terms of what is described, I believe the recipient witness or the only witness in this case talks about discomfort. She talks about not being comfortable sitting in school. So I would submit that they were temporary issues, temporary discomfort that do not rise to that level of loss of impairment or bodily function. And I would submit to the court that those kind of allegations do not amount to the serious bodily injury or the risk of serious bodily injury that is required under the case law and under the model jury instructions. And I would add also that there is a discussion of eating or testimony regarding eating moldy or rotten food. Throughout this, we have no expert testimony. We don't know anything in terms of medical records, and if we're talking about any beatings, if you will, and we don't have any records as to what evidence or what harm, if you will, or permanent harm would arise by a child eating. And I would submit to the court there's really one occasion of this moldy food that was not even consumed, but what would have happened if the moldy food was consumed. And I would submit that does not rise to serious bodily injury. And then again, that leads us to the third allegations, which I submit to the court, were speaking of the youngest child being left home alone. I would submit that the evidence would suggest that that was a one occasion time in which the witness testified that she did not even inform KYAMBADDE regarding this. And
I thought she said it happened enough times.
Well, Your Honor, agree that I strike that. I think that was Mr. KYAMBADDE's testimony. But in terms of, I think the testimony was that she did not bring this to the attention. And certainly where my client, again, is working this extended period of time, my client is not aware that this was going on, it appears like from the evidence. And further, we don't know exactly what the risk was, if you will. Even if this is a risk, how long the child was home alone, in what situation they were left, were they left in their crib? What was the situation?
I think that we were told that the child was left sometimes on the couch.
Oh, understood, Your Honor. But even in regard to that, again, the environment, I think, would be important to know with the setting in terms of the entire room, what was going on with it. And also, again, my client must be aware of this. And if my client is not aware of that, I would submit to the court, it does not rise to that level. In addition, I would submit to the court that there was no jury instruction that this was a conviction based on a general verdict. And I would submit to the court that we're not talking of one single episode of continuous conduct. We're talking about 3 different incidents that the Commonwealth brought to the attention of the jury.
But doesn't the not guilty verdict in some respects really truncate that argument? Because it's clear that the jury was able to understand, and you look at the verdict slips as to what each incident involved, or what allegation each incident involved.
Well, yes, Your Honor, except that, but the prosecutor argued all 3 as being involved specifically in terms of the endangerment issue. In their closing argument, I believe they spoke to all 3. They talked about the beating, they talked about the moldy food, they talked about leaving the youngest child alone. So I would submit to the court that the jury, therefore, could take that information that was provided to them in the closing argument and use that in regard to their guilty verdict. And that I would submit that the Commonwealth failed to prove beyond a reasonable doubt each of the 3 theories regarding the endangerment. And I would submit to the court that obviously counsel or trial counsel did not bring this to the court's attention, and therefore it would be reviewed under the substantial risk of miscarriage of justice. I would submit to the court, in looking at all the facts in terms of the testimony, that it would have materially influenced the guilty verdict in regard to the case.
Can I ask you about your 3rd issue? Because the Commonwealth says that you've essentially changed up essentially your offer of proof from what trial counsel said to what you're saying on appeal. So could you address that?
Certainly, Your Honor. Your Honor, I would submit to the court that there was a ability to cross-examine that was undertaken. There was the judge shutting it off. There was a sidebar. There was a discussion in regard to that. And then I would submit to the court that then the defense attorney kind of changed, if you will, changed tactics and was asking about other areas of concern that would show, I would submit to the court, motive, or would show bias, other issues that they were trying to present to the jury, and that the judge stopped that line of questioning, obviously agreeing with the Commonwealth's objection. And further, that the court didn't allow defense counsel to go to sidebar. So then they could expand on the record, specifically what they were trying to do and where they were trying.
Did trial counsel say that it was being offered to show bias?
If I could just have a moment. Your Honor, again, I think what we're talking about is kind of two different tracks, if you will. We're talking about the initial track, and then when the judge shuts it down, said we're only talking about Waltham, Massachusetts. I think then the matter is kind of closed, and I think the ability of trial counsel should look at all the issues in terms of trying to go after credibility, bias, prejudice, in terms of the sole precipient witness. And I think that's the most concerning thing about this case. This is the sole precipient witness, and not to be able to fully examine that witness to all the issues in terms of bias, in terms of credibility, in terms of prejudice, particularly when you're talking about a situation where In a sense, you even have information that was presented by the defendant in this case, talking about what happened as far as she was concerned, and the ability to have cross-examined the percipient witness that would have very possibly shown the difference in terms of the witness could have supported Ms. Nababi's statement. And therefore that would lead the grand jury kind of down a different view in terms of being able to render a fair and impartial verdict. So I would submit for those reasons that it was very substantial that the trial counsel was not allowed to fully develop and cross-examine the witness, and also not allowed to come to sidebar to fully explain to the court what their reasoning was in terms of wanting to go in this direction in regard to their cross-examination. And the last issue that I did raise for the court was the issue regarding unanimity instruction regarding the assault and battery with a dangerous weapon. And that basically involves the fact that we were talking a kind of an expansive period of time in which my client is alleged to be with the children on one occasion, and yet Mr. KYAMBADDE was alleged to have undertaken the discipline over a long period of time, my client at times being there and not being there. And I would submit to the court the same arguments regarding unanimity instruction would apply as argued in the endangerment charge. Thank you, Your Honor.
Thank you very much. Excellent argument. I think we understand it, and we have your brief. We will hear now from Attorney Nagin. Attorney Nagin.
May it please the court. My name is Nicole Nagin, and I am an assistant district attorney with the Middlesex District Attorney's Office. Turning to the first issue addressed in the Commonwealth's brief, there was more than sufficient evidence presented at trial that defendant Nababi wantonly or recklessly engaged in conduct that created a substantial risk of serious bodily injury to all three children, KK, MK, and BM. While my sister argues that there are three distinct theories that the Commonwealth argued in regard to this reckless endangerment charge, it's important to remember that these reckless endangerment charges were indicted and tried as to each defendant and each victim. So in analyzing this risk of harm, we must look to the harm alleged as to, or the potential harm as to each child here. So when conducting the Lattimore analysis, we must consider the evidence in the light most favorable to the Commonwealth as to the harm that could have been created to KK, to MK, and to BM.
So are you saying that it doesn't matter if there is sufficient evidence with respect to a particular act or acts of endangerment with respect to one of the children, that the convictions can stand anyway? Let me be more concrete, and I want you to address sufficiency here as well. But let's say there were inadequate evidence that the mother knew that the baby was left alone by her, whatever he was at the time, boyfriend or husband. Okay, so can that conviction, reckless endangerment of that child, can that stand even if there's no evidence of her knowledge?
If there is no evidence of a wanton or reckless conduct, the evidence couldn't stand. But I would argue in this case that there is certainly evidence that here defendant Nababi acted wantonly or recklessly as to all three children.
No, but you're not answering my question. I agree with you that there is evidence of wanton and reckless conduct as to each child. But what if there is no sufficient evidence that the mother knew of the baby being left alone in the house? What if I conclude, well, let's start with that. What do we do with that conviction if there's no evidence? There's evidence of everything else, but not that. Go ahead.
If there's no evidence of that, I would still say in this context, whereas there is a continuous allegation of harm, all of which in combination could rise to a substantial risk, then there would be sufficient evidence in the case. If you're looking at discrete acts, there's many times in abuse cases where a parent is charged with reckless endangerment, but does not know as to each specific act that happens to the child. But nonetheless, a reasonable jury could conclude that the defendant was wanton or reckless in their conduct and should have been aware.
Is there ever a time when there has to be specific unanimity about a particular act in a reckless endangerment case? Or is it always simply about creation of an environment that's dangerous?
Turning to the unanimity issue, Your Honor.
But these are related, I think. I may be wrong, but I think they're related.
They are somewhat related in the context of continuous acts. If it is a situation where it is not a continuous act distinguishable from a case like Cashbaum, then there are situations where you would have to talk about the particular act because it's one incident that's leading to the charge, such as in the case in Hendricks, for instance, when there was one incident where the defendant was driving recklessly. If someone else was aware of that, as was the case in Rogers, which Your Honor sat in the panel, the defendant was aware of the bank robbery and was sitting in the car. That would be a situation where you have to prove, you have to be a bit more strong as to what's occurring as to each particular act. But when you have a series of acts, it is distinguishable because you don't need to flesh them out in the sense that it's this continuous repeated situation that creates the substantial.
Do you have a case, or what's your best case for concluding that it's a case charging a continuous course of conduct that is instantiated through a variety of different acts? That is, it seems easier to me to say all the beatings with a stick are a continuous course of conduct. What did this man do? He beat the child with a stick over a long period of time. Okay. But now when we say, oh, he beat the child with a stick, and he fed her spoiled food, and he left the baby on the couch. Now, maybe the argument is, look at this horrific environment. That's reckless endangerment. The way it was argued was there are these three things, but okay. Do you have a case where conduct of different characters are used to show a continuous course of conduct?
Could I answer your question in two parts, Your Honor? I'll first address the case, the case, and then I would just like to address the distinct theories because I think that's really important in this case. As to the case, I think there's a couple of different cases, but I think the Commonwealth v. O'Brien, while being an unpublished decision, is a case cited in the Commonwealth's brief. And that's a case where the court fleshes out the two theories as being that of leaving a hot iron plugged in with the child, and then of failing to take a child for medical treatment once they have been burned. And in that situation, the court says either harm is sufficient here because the risk of harm from the hot iron creates a substantial risk of a serious bodily injury, and failing to get medical treatment promptly also is at risk. And so those are separate, that the court fleshed out as two theories. But what I would point out to the court, both defendants, defendant NABABI makes light of the fact that this moldy food theory is a distinct theory. But I would argue it's very important to look to not only how this issue was argued, but also how the testimony came out. The testimony from KK was that there was two incidences related to food. First, she generally described how she had to cook fresh food for co-defendant KYAMBADDE on a regular basis, and that her and her sister had to eat leftover food that had been in the fridge for weeks. And she describes that the food is rotten and moldy. And when asked what happens when she wouldn't eat the food, or when co-defendant NABABI found out that she didn't eat the food, she described how she was beaten, just how she described how she was beaten when she failed to do a chore correctly, when co-defendant KYAMBADDE thought that the girls were lying. So this is just that continuous repetition of beating, of assault and battery with a dangerous weapon. The moldy food is not a distinct topic.
So, well, I'm not sure you want to say that, but we'll keep going. I don't know why it isn't reckless endangerment to feed children moldy food, but let me, Your answer to my question is there's an unpublished decision. You have no published decision that delineates or that holds this is a single course of conduct, not separate acts, and they are of different character. Is that correct?
Your Honor, I would also say there are published decisions. I just think the O'Brien case is helpful in
Okay,
regards.
well, I need that's not precedent, as you know, or it's valuable only for its persuasive authority. If you had a controlling precedent, it would be a lighter lift for you.
Yes, Your Honor. So in Hendricks, the court articulates that there's two different things that are occurring. The first action that the defendant does is he's driving away from the police at a high rate of speed with an infant and a child. Then after, the car goes into the woods, and he then starts running away from the police, holding the child. And the court in that case analyzes the two different things that occurred there. The risk to the child when the defendant is driving away at one high speed. Those harms could be a variety that a reasonable jury could come up with, a car crash, a variety of things. And then the second harm is the running with an infant in your hands away from the police. And the court says, well, it's reasonable that the defendant should have known that the police would have chased after him, and that would have created additional harm to that child. And so in Hendricks, the court is essentially articulating that even though there's one form of conduct here, we're looking at these two supposed distinct theories. And I think that that's quite similar to what would happen in this case when you have this continuous action, and each of these things just add on this substantial harm that could occur to these children based on what both defendants are doing. And if I could address the issue as to co-defendant Nababi's knowledge, it's important to note here that the testimony at trial was clear. KK testified that on occasions, her mother, defendant Nababi, was the abuser. She used a dangerous weapon, to wit, a stick, which KK described as being approximately 2 feet long. She described the thickness.
The only question I'm raising about knowledge is about leaving the baby alone.
Okay. So as to knowledge as to BM and what that would mean, what I would first articulate to the court is, as noted, that the testimony was that the child was not left alone frequently, but it was enough, that there were multiple occasions that this happened. KK also testified that she had a key to the apartment. And so at the time that all these events were occurring for approximately 2 years, it was known to the jury that this BM was an infant. He was newly born, I believe, in the second year that the girls were in the United States. And it was known that the mother worked frequently. And so the KK testified that she had a key to the home. And so a question is, why do you need a key to the home if you're not letting yourself in, if there's no guardian present? And so while there was not testimony that Nababi knew that the girls had a key to the home, it is certainly reasonable for a jury to infer that a mother would know that when her children are at home, or supposedly at home with an adult present, they wouldn't need a key because the adult would let them into a home. Mind you, these girls at the beginning of this incident are 6 and 9 years old. These are not, teenagers. These are young children.
But that doesn't mean that the baby is inside the empty apartment.
There was never testimony by KK or MK that the baby had been taken to church on a regular occasion, but it would certainly be reasonable for a jury to infer that based on all of the conduct that was going on with co-defendant KYAMBADDE when defendant Nababi was present, that these things did not just end as soon as co-defendant Nababi left the home. And so based on the fact that the girls testified, KK testified that she was constantly taking care of the baby, bathing the baby, feeding the baby, all of these things, that a reasonable jury could infer that if the girls weren't home, co-defendant KYAMBADDE was certainly not doing those things. And so because the defendant's conduct was wanton or reckless in just ignoring defendant KYAMBADDE's complete disregard for all 3 children, it is certainly reasonable for a jury to infer that defendant Nababi knew that she was just as neglectful or just as wanton or reckless as to BM, particularly that this happened on more than one occasion. And while KK said that she never had to tell her mom of this particular incident, it would have been known to her based on what was occurring in the household. I will also note that as to the beating of BM, there was testimony that defendant Nababi was possibly present for that incident as well. And
let me interrupt, please. Along those lines, going along what Justice Rubin was asking. So as the youngest child, BM, there was evidence of beating with a wet handkerchief, and there was evidence of leaving alone. And as to the theory of proof, are both necessary? Is it necessary that NABABI be aware of both in order to sustain the conviction against her?
I believe that this court could look at it in either way. If the court wanted to view this as continuous conduct, I would answer no, it's not necessary. However, I believe that if the court wanted to flesh out the distinct theories and view them as distinct theories, it would be acceptable here because there was evidence that co-defendant Nababi knew about all three. And so whether it's continuous or not, the evidence here does show that co-defendant Nababi was aware and or had participated in what had occurred. And
does it matter that the jury was hung on the count against the man for the handkerchief as a whip?
As to co-defendant Nababi?
No, that wasn't the jury hung on the count of assault on the youngest child?
I believe as to defendant Nababi, that was a not guilty, and as to defendant KYAMBADDE, it was a hung jury, is my recollection.
So how can you, so if the jury couldn't unanimously agree, now maybe it's not serious bodily injury, I don't know why they couldn't agree or why they acquitted, but doesn't that make it harder for us to say it doesn't matter that was, does that make it harder for us to affirm on your sufficient evidence of separate facts?
No, Your Honor, it does not. I think what's important to note is that at the Lattimore context, we're not at a beyond reasonable doubt this has to be. At the Lattimore context, we are considering the evidence in the light most favorable to the Commonwealth. And so certainly if a reasonable jury could make a conclusion, that doesn't mean they have to find beyond a reasonable doubt that the defendant is guilty. So the evidence was certainly sufficient on these theories to go to the jury. Now, the fact that the jury—
Okay, your time, I'm sorry, your time is, I know it's now says 14 minutes for some reason, but in fact, your time has expired, although we have the great good fortune of being able to hear from you again in about 15 minutes. So that first case is submitted, or first of these two paired cases is submitted. And the next case we will hear is number 19-539, Commonwealth versus KYAMBADDE. And we will hear first in this matter from Attorney Drexler.
Good morning, may it please the court. Attorney Justin Drexler for Richard KYAMBADDE. So, Your Honors, we've covered a lot of the topics here, so I'm going to try to address some specific questions that the court asked for the first time through, which is first, with regard to the required finding. It's difficult for me to see how the Commonwealth gets out from under Rogers. I understand that Rogers is an unpublished opinion, but it does articulate principles that apply to this case. So Rogers, I think, very clearly shows that reckless endangerment is not about creating this reckless or creating this continuous course of conduct that creates a dangerous environment. Reckless endangerment is about specific incidents. There you have a situation where at literally the exact same time, this woman is driving to the bank robbery and has the hypodermic needles in her car. They are temporarily related and they are contextually related. And still, this court says, no, these are two completely distinct theories of guilt and they both need to be proven. If this was about creating a dangerous environment, Rogers just would have come down differently. Rogers would have said, well, of course, it's a wildly dangerous
environment. What's our standard of review of this claim?
On the motion for a required finding, it's de novo, because this is a situation where it's a question of law.
No, I'm asking whether it's substantial risk or prejudicial error.
Well, I don't think in the context of a motion for a required finding, I don't think either matters. Sufficiency of evidence, it's not. So in the context of a required finding, I mean, it doesn't matter either way because it's always a substantial risk of miscarriage of justice if the elements of the offense aren't met. And so I think in any event, it makes no difference.
Okay, but unlike the co-defendant, there is, it seems to me, sufficient evidence. Again, leaving aside the question whether these, well, for reckless endangerment, let's start with that. There is sufficient evidence with respect to your client, even if these are three distinct theories, for each of the three theories. That is, he's the person who is alleged to have beaten all three children, including the baby with the handkerchief, right? He is alleged to have fed the children this spoiled food, and he is alleged to have left the baby alone on the couch and gone out of the apartment, right? So
Yes.
that's if, I'm not saying what happened, I'm saying viewing it in the light most favorable to the Commonwealth, there's enough for all of it. For each.
That I disagree with.
Okay, I don't get it. What is missing?
Well, what I disagree with is I don't think that there was sufficient evidence for reckless endangerment on any of those three theories. So
Why?
with regard to the
Why isn't leaving a baby on a couch reckless endangerment?
Because we have no idea how long that baby was left on the couch. It
How
literally
many-
could have
how
been
many-
30 seconds.
Yeah, it could have been.
And this is the Santos case. Santos says leaving
Santos
a child
is
on the
someone
couch-
going to a bathroom and coming back out. This is leaving
Sure.
the apartment, and whenever the girls get home, that's, what if the girls don't get home? It's only got to endanger, right? It doesn't
Sure.
have to happily come to fruition. Who knows? Maybe they had to stay after school. Maybe they were in a school bus accident. Who knows when they're going to get home? I don't.
That's true.
All right, but
It's true.
so if there, well, let me ask you it as a hypothetical then, if you don't, and I don't ask you to concede anything. If there's sufficient evidence as to all three types of acts, how is there a substantial risk of a miscarriage of justice in the verdict?
Well, I think this actually dovetails with argument number two. And the reason is because they could mix and match factual findings. So some of them could have thought that there was enough, that the moldy food was sufficient to create a substantial risk of bodily injury. Some of them could have said, no way, moldy food, I eat moldy bread twice a week, and there's no substantial risk of serious bodily injury. Others could have said, well, these assaults are really outrageous. That's a substantial risk of bodily injury. And then with regard to BM, we have no idea whether they agreed with Your Honor.
But they did convict this same defendant of the assault and battery charges, right?
Mhm.
With, at least with respect to the two older children with a stick, right?
They did, but you could, and this actually gets to Justice Blake's question to Ms. Fund earlier. So I don't actually think you can come to a definitive conclusion. There certainly are times when you can, and you can say we've got a not guilty here, a guilty here, and you can just infer, but you can't. Because here, there's an element of reckless endangerment that is lacking in assault battery with a dangerous weapon. So they could have said these ABDWs happened, but we don't think they were as severe as these children said they were. So there wasn't a substantial risk of serious bodily
But,
injury.
but we're looking at substantial risk of miscarriage of justice, and as I understand it in this context, I'm looking at Comtois. We have to figure out if it does not appear likely that the jury verdict would have been different, even if the judge had given the specific instruction now requested. So we don't have to be certain. We have to figure if it appears likely that it would have been different. And certainly I can agree with you that we can come up with ways, but our judgment doesn't have to be certitude. And given the other convictions, well, first, I again, I don't want to ask you to concede something because that's silly.
Anyway.
No, I know, but right. But do you agree that that's the standard? That what I read is the standard for substantial risk?
I agree with regard to the specific unanimity instruction. That
Okay.
Substantial risk of miscarriage of justice is most certainly the correct standard of review.
All right.
And I think the issue with I think these issues, the required finding and the specific unanimity, they are related, but they are distinct issues. And so with regard to the required finding, you have to ask the question, was there sufficient evidence for these theories? And did they present these distinct theories? It actually doesn't even matter if they presented them as distinct theories, because Rogers teaches us, even if the Commonwealth says this is cumulative, doesn't matter. If two distinct theories exist, that's what matters. So if one of those theories doesn't have enough evidence, then it's gone. Specific unanimity is different. It's a different question here, which is the substantial risk of miscarriage of justice, where we really need to ask ourselves, well, should there have been a specific unanimity instruction? I think the answer here is yes. I think that, I mean, the Commonwealth has pointed to no cases, including O'Brien, no cases, and what was the other case the Commonwealth cited? Hendricks. Neither of those say that there shouldn't have been a specific unanimity instruction. Actually, O'Brien says, yes, there should have been a specific unanimity instruction, but we don't care because everything was proven anyway. And so it's no big deal. But O'Brien says these are distinct incidents. There should have been a specific unanimity.
What is the line between specific instances and, you agree sometimes we say course of conduct and sometimes we say not. Can you figure out what the line is?
I can in this case. I do think it's.
I'm not asking, I get it. I'm asking what the line is because we ought to articulate a clear rule for future cases. So what is the line?
Well, I think when an individual identifies a specific date that has facts and circumstances that are distinct factually and contextually from the others. So what KK describes is this lengthy period of time where they're being beaten every day. She can't really give any specific instance. Then she says, June 2014, this is the date this happened, day after the Mother's Day banquet, describes that. That incident is also corroborated by a bunch of other evidence. Now, whether that evidence is to be believed, again, I'm not going to concede, but it has corroboration distinct from all of those other things. And it has corroboration in the fact that Mr. KYAMBADDE is saying he did it. So Mr. KYAMBADDE is saying, I did this.
Yeah, but that's just the strength of the evidence. Did the indictment here have dates on it?
It had dates, but they were lengthy. It was diverse dates from, I think I know them. I don't have them written down. But
Was there a bill of particulars filed?
Not that I know of. And so,
I mean, diverse dates, I never know what to, right? We're told that's not part of the, like, not an essential part of the indictment or something, but there it is. And then it's like, can it be that the prosecutor gets to decide whether to charge it as a course of conduct or not? That can't be right. They would just always say it's a course of conduct and not have to worry about specific unanimity. So I just want to know what the line is.
Well, I think they can always charge as course of conduct. I do. And then the way the evidence comes in determines whether there needs to be a specific unanimity instruction. And the reason they really needed one here is because it's so factually and legally complicated.
But it's very bizarre what you're saying. You're saying that if your client had not admitted June 14th, this would be a course of conduct case. How can that be what it turns on?
I'm not quite there, Your Honor, because KK identified one specific instance.
Okay, let's say she couldn't. Let's say all she had was, let's say the facts in real life were exactly as they are here. But she didn't know what day different things happened on. And she just said, and one time he beat me and I and at school, the teacher talked to me and one day, right, whatever it is. And let's say we get nothing else. How can it be that the quality of the proof, that weaker proof, which is what it would be if she had no specific date, that weaker proof makes it easier to convict? How can that be?
Strange quirk, Your Honor, but I think that's how it would work. In the case of a delayed disclosure case, this happens all the time, where we've got diverse dates, we know this is course of conduct, but it really does change things when the jury is given more information and when the defendant makes certain admissions. It really does, because it opens up the possibility of mixing and matching verdicts. Now, you could say, well, that creates a perverse incentive for defendants but for what? You can't blame a defendant for telling what he perceives as the truth. If you give me that Mr. KYAMBADDE is telling what he perceives as the truth, you can't punish the defendant for that. So he is allowed to own specific incidents and still get a specific.
I don't understand how the mix and match problem is solved in the course of conduct case. Let's say she says, I was beaten routinely from the beginning of one year till the end of the next year, almost every day, blah, blah, blah. One time I couldn't sit down at school. One time I did that. One time, and 7 of the jurors think like, well, if she said couldn't sit down at school, that sounds specific. I think that one happened. And another one says, You know, she said her hands were touched. She'd remember that day pretty well. So I'm going to say that one. And now you've mixed and matched.
Sure. And you've mixed and matched in that situation where we don't have Mr. KYAMBADDE, and where what you're describing, Your Honor, the issue here is all or nothing. Right? That's the principle we're trying to avoid. Is if it's an all or nothing, we don't need specific unanimity. Either you believe nothing this person says, or you believe everything this person says. That's where you don't need specific unanimity. As soon as the case becomes something other than an all or nothing case, you have to have specific unanimity. And that is what that is number one, what Mr. KYAMBADDE
It's an all or nothing case.
No, it's not at all. That's the problem.
But even when we change up what we're talking about, she says every day, I'm a juror, and here's what I think. And this isn't what I think, but hypothetically, I'm a juror. I sit there and I say, geez, she says every day. Every day is a lot. I don't think it was every day. I think it was some days, right? I believe her in part.
Mm-hmm.
Right? Have we now introduced the need for specific unanimity?
Well, that's a difficult hypothetical because we've never been in the jury room. But I think that is a risk during diverse state cases, certainly. But the courts have decided that because diverse state cases almost always present an all or nothing, again, because they almost happen in the sense of delayed disclosure, and the defendants are almost always denying it altogether, that's different. I also do think the parental privilege defense here is really important. I think it adds a quirk to it because it gives the jurors an out for the instances where he has admitted to them. They might say, okay, well, like on this specific incident, the parental privilege applies. And I think it's fine. I believe that he used appropriate discipline in that case. But if he'd beaten them every day, then it doesn't apply to those repeated beatings. So maybe they give him the benefit of the doubt in the parental privilege, or some of them do. And then they say, but look, they got these bruises. Of course, this girl's getting beaten. So they hear on the diverse states. Other jurors might say, those diverse states, there just isn't enough proof. Like, you got to give me more. But we've got this other one that's really corroborated. And I don't buy parental privilege. No way. It's too much. You can't beat a kid with a stick. You can't beat a 9-year-old with a stick. That possibility is real. And I don't mean a little bit real. It is real in this case. The jury is struggling with everything. Absolutely everything that they come down. We can see that they are struggling. We don't know if this was a compromise verdict. We don't know who believes what. We just don't know. And that's why we need specific unanimity. It's why you need it. There is a very real chance that this jury convicted by mixed and matching verdicts, because we know that they've already done it. We just know that they did it. I just with my remaining 20 seconds, if you don't mind, Your Honor. Two things. Number one, with regards to the moldy food, I think that's controlled by Rodriguez. In Rodriguez, they say cocaine residue doesn't necessarily create substantial risk of bodily injury unless we've got somebody in here telling us what it does. Moldy food is an order of magnitude, maybe 3 orders of magnitude below cocaine. With regard to the bias issue, that was signaled from opening statements. I wrote that in my reply brief. I think that's really important. The judge was on notice, and this is about notice. That's it. Unless the court has anything else.
Well, your time has expired. Are there questions from the other judges? No. We will hear once again from you, Attorney Nagin.
I will turn to the unanimity issue first, and I would like to just address it in 2 parts. I would first like to address Justice Rubin's question as to where is the line for the continuous conduct question, and then I would like to address the standard that we are under the substantial risk of a miscarriage of justice, because I think that's really important in this case. As to the continuous course of conduct, the fact that co-defendant KYAMBADDE in his brief articulates, well, there's this one incident, June 2014, this is specific, so therefore, sua sponte, the judge should have given a unanimity instruction, it is false. And the reason that it's false is because in all of these cases involving sexual abuse, starting with cash bound and a variety of cases, there are always times, whether it's the start of the abuse or the end of the abuse or one particular incident in between, that a victim can testify as to a certain time frame that one thing happened and it was really concrete. So in cash bound, what we see is it's clearly a continuous conduct case. There's no unanimity instruction there, but the beginning of that event was approximately the girl's 16th birthday, and she describes how she starts this nannying job, and then she describes in detail the sexual abuse for that day. And then she continues as to what happened day.
So what is the line? How do we decide which cases have to be specific unanimity and which ones it's okay to just say this is a course of conduct? What's the difference?
So I think the difference comes down to two parts. When the victim speaks about concrete dates and concrete incidences, as is the case in Commonwealth v. Ramos, which is cited in the defendant's brief, where there's literally 5 incidences that happened at different times, different dates with specific acts, that's not a continuous course. And the second line that should be drawn is, well, when a defendant requests a unanimity instruction and argues for this, then the judge can flesh out these distinct acts with the parties and distinguish where we are. But in a case where the defendant is now arguing that there's one distinct act, which is the date of reporting, which is of course why it is corroborated by other evidence, that is not the line where the continuous act argument falls apart.
I don't understand your distinction. I mean, I understand well, as to the second part, we still review for substantial risk of a miscarriage of justice. So merely not requesting it apparently doesn't eliminate the possibility that you need specific unanimity. As to the first one, which is more serious, it seems to me, a victim who keeps a diary has a harder time seeing her abuser punished than one who doesn't. How can that be?
I don't know that a unanimity instruction necessarily means that it's a harder time. Sometimes it could be how it's indicted or how it's charged, that they have distinct actions. But in a case where there are certain instances where a jury could agree as to one and not the other, it might be possible that a unanimity instruction is required.
In every case, as a matter of fact, there is that. We just don't have evidence of what those dates were, unless the person kept a diary or took note of certain dates, my birthday party, whatever, right? Yeah, please.
I mean, if the child was able to tell about the first being hit with the switch over a clothes as a distinct event, and then said 2 weeks later it was a bigger stick, and then a month later it was the end of a plunger stick, and then I was naked, and then giving specific. If the child was capable of giving specific dates, then would the jury be able to say that one event of switching the child over the clothes, did that constitute reckless endangerment of a child? Whereas the continuous course of conduct over a period of time could lead to jury to believe that it was. So I follow what Judge Rubin's saying. If you had a child that was able to say, I marked on the calendar every time I was swatted, and this one was with a stick, and this one I had my clothes off, and this one I had my feet tied, the jury would be forced to look at each one separately to determine if that event caused reckless endangerment. It's apparent here that the Commonwealth used a continuous series of events, including the possibility of throwing in the food, of like creating a picture of an environment the child was living in. So is that appropriate under our case law? Not just because it's diverse dates, but to lump everything together to say that whole picture constitutes reckless endangerment as compared to each separate act.
It is, Your Honor, and it's entirely possible and appropriate because of the fact that it's all one and the same. As to the reckless endangerment charges, I talked about this earlier, but that the moldy food was not distinct. It was part of this continuous conduct that failing to do what the defendant KYAMBADDE requested of the girls, ridiculous or not, resulted in these constant beatings. And so the unanimity issue was not significant because it was day in and day out. And so the distinct dates were irrelevant to the finding of guilt here. And I think it's just important to note that there was distinctions in regard to the assault and battery with a dangerous weapon. And it's important to look at the testimony in that unanimity issue because the jury was given the opportunity to say, well, did it happen continuously with a stick? Did it happen continuously with a belt? Did it happen continuously with a handkerchief? And they were able to say, no, it didn't happen continuously with this beyond a reasonable doubt, but it did happen continuously with a stick. And that's what the testimony showed. But turning to the substantial risk of a miscarriage of justice issue, what's important here is that we have cases that hold that even when a unanimity instruction is perhaps required and wasn't given sua sponte by the judge, such as in the case of Commonwealth v. Ramos, where the court said it should have been given because there was 5 distinct issues. Nonetheless, any error by the trial judge's instructions concerning the need does not create a substantial risk of a miscarriage of justice. And I think here that is significant because the jury did flesh out these issues sufficiently. They found that both defendants were not guilty, for instance, of the conduct against BM, which was just assault and battery. It was not assault and battery with a dangerous weapon. It was assault and battery against BM. They found them not guilty of that, but they did find them guilty of reckless endangerment of BM. And so clearly they were fleshing out these different issues and finding guilt. Similar to the charges of the testimony by KK was that she couldn't really recall how many times she was beaten with the belt, but she consistently recalls being beaten with a stick, and the jury was provided this stick to analyze as a weapon. And so the jury was able to say, well, beyond a reasonable doubt, we can't say that the girls were continuously beaten with the belt, but we can say they were continuously beaten with a stick. And so in looking at these verdicts, we can see that there was not, while my brother argues that we don't know what the jury did with this. Well, we know that there was no substantial risk of a miscarriage of justice because the jury was able to flesh out these issues sufficiently. The argument that the defendants also conceded that these events happened in no way creates a different standard that we should be looking at here. The arguments presented by the defendant was KK is lying. This did not happen every day. This was not a case of continuous abuse. Rather, we were punishing the girls as we saw fit. That is no different than the case of Commonwealth v. Ramos, where a victim made an allegation and the response was, well, that's false. That's exactly what happened here. And because we see that the jury fleshed out these issues, I would first argue unanimity instruction was not required because of this clear continuous conduct. But even if it was, it's irrelevant because there was no substantial risk of miscarriage of justice. I will just turn briefly to the third issue addressed in the Commonwealth's brief regarding the cross-examination, if there's no further questions on these unanimity and required finding of not guilty issues. The theory raised on cross-examination of KK in regard to both defendants was when they asked the girl about her life in Uganda, specifically about who she was staying with. The theory was that the testimony about that would go to co-defendant NABABI's state of mind, particularly that if there was information that she found out that the girls were being harmed in Uganda, she did something, and she would have done the same thing in this case. However, that testimony was not allowed, and it was not allowed for multiple reasons, but it was appropriate for the judge to exclude that. And as the Commonwealth noted in the sidebar at the issue, that testimony involved a lot of hearsay, in addition to the fact that the state of mind argument the judge could disagree with. The argument now that this testimony of Uganda is now related to bias is incredible for several reasons. While there was not a particular sidebar about the issue of bias, it's important to note that if the defendant wanted to raise this issue, they could have raised it at the first sidebar and said to the judge, well, I'm not going to raise it in regards to state of mind, but can I still talk about it in regards to bias? They had that chance, they didn't do it. But in order to show bias, you also have to lay an appropriate foundation. And it's somewhat contradictory to say, well, KK was biased because she had such a great life in Uganda that of course she didn't like her life in the United States. Meanwhile, what defense counsel was proposing moments before was that actually KK was being abused and not treated properly in Uganda by the mother's former boyfriend. So that in and of itself creates a problem. But the fact is, no defendant was foreclosed of cross-examining KK as to this bias issue, particularly after co-defendant NABABI cross-examined KK, co-defendant KYAMBADDE's trial counsel came up and cross-examined KK and specifically asked, how did you go to school in the United States? Oh, well, I had to take a bus when I was living. And then asked, well, with your foster parents, how do you go? Oh, my foster mother drives me. When you were in Uganda, do you recall how you got to school? And she testified, no, I don't remember. And then counsel asked, well, did you not have a driver? And she said she didn't recall which makes sense in light of the fact that this happened many years before trial. But the opportunity to ask about that was certainly allowed. It was not objected to. And then both defendants, particularly defendant NABABI, presented this exact story in her defense. She testified that she sent money back to Uganda, that money was used and the girls were taken by a driver to school. And she explained that. And so the concept that this bias would somehow have changed the verdict clearly is irrelevant because the jury heard about it and it didn't change the verdict. So they were not foreclosed of presenting any particular defense into this bias issue. Moreover, bias was fully explored as to the benefits and privileges that KK and her sister had while living with their foster parents. And so I think any argument about bias is simply irrelevant in this context. And so if there are no further questions, I realize I have spoken quite at length now, I would rest on my arguments and the Commonwealth's brief.
Seeing none, thank you very much. An interesting case and excellent arguments by all three of you. Thank you very much. Very helpful to us. The case is submitted.
Thank you.
Thank you, everyone.
We are live and recording.
Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin. I am joined today by my colleagues, Justice Blake and Justice Lemire. The next case we'll hear is number 20-475, LOHEAC versus Aldeborgh, although I'm guessing I may have mispronounced a name or two in there. The rules for argument by teleconference, which is what we're having today due to the ongoing pandemic, are the same as the rules for argument in our courtroom, which is to say 15 minutes per side and no rebuttal. And we will hear first from Attorney McElhenney.
Thank you, Your Honor. Good morning, Justices. May it please the Court, my name is Colleen McElhenney, and I represent the appellants, the plaintiffs Suzanne LOHEAC and LTA LLC in this matter. The issue for Your Honors to address today is really quite simple: whether the plaintiff's complaint has sufficiently pled a claim for violation of Chapter 93A, Section 11, or to be procedurally precise, whether Judge Fahey's decision dismissing only the 93A claim with prejudice, despite also finding numerous other counts based on the same wrongful conduct to have been sufficiently pled, was an error of law. As pointed out in our reply brief, in the appellee's brief, there are a number of misstatements of the factual record, misstatements of the substantive law, and misstatements of the procedural rules, which I will address specifically in turn. However, these tangential issues should not distract from the essential question that is before this court, where the standard of review of this purely legal question is de novo, and where the only necessary portion of the record for Your Honors to focus on is the complaint itself. The rest of these issues are simply distractions. When you consider the complaint and whether the 93A count has been sufficiently pled, a few key concepts must be kept in mind. The first concept is that the complaint alleges 3 separate acts by the defendant, a person engaged in trade or commerce, that were deceptive and or unfair business practices, misrepresenting to the plaintiff, Suzanne LOHEAC, the seller's intentions regarding the property. Second,
But when she got
misrepresenting
the, can I just ask you though, when your client received the P&S, you don't disagree that that term is not in there about the furniture, right?
Are you referring to the purchase and sale or to the contract to purchase that was?
The purchase and sale.
Okay, the purchase and sale that was engaged in later, there's no dispute that by that point, the plaintiff had realized that Mr. Aldeborgh had not included the furniture provision in the binding contract that had been entered in previously. That
And
is
if
correct.
if your client walked away, is it true that it was a $1,000 deposit that would have been lost?
The contract to purchase did have a $1,000 deposit, but in terms of her loss with respect to the wrongful conduct by the defendant, the loss is not limited to that. The loss
Because it's the loss of the property as well,
Yes.
potentially.
Yes.
Okay, so now keep stepping back in time with me. At what point do you say from the P&S backwards that the defendant made a misrepresentation?
The misrepresentation was made when the defendant was representing prior to the contract being entered into, the binding contract that was entered into on April 23rd that he drafted, that the plaintiff signed and the seller signed. And at that point, there was a binding contract that our client had entered into. So his misrepresentations occurred prior to and in conjunction with that event. So at that point, she should have had a binding contract for that property at that price with that furniture. And because of the defendant,
some furniture was there and some furniture was not, right?
So the complaint specifically states that the furniture that was there when she viewed the property, it was beautifully staged, presented for sale, that furniture was removed. Some items were replaced, but the complaint specifically says most were not, and that the replacement pieces were of an inferior quality. Yes.
And so then what is the document in the record that you want us to look at that shows that it was the furniture, when the house was initially staged, that was to be part of the contract? What document in the record do you rely upon?
It's the sole document in the record that is at issue here is the pleadings in the complaint and the sufficiency of the complaint. And it's alleged specifically in the complaint that the defendant represented to the plaintiff that the deal was for that property at that price with that specific furniture that was on the property when it was viewed. And that was repeatedly stressed as being a very
what
material
paragraph
element.
of your complaint is that set forth?
Sorry?
What paragraph of your complaint? I'm looking at
in numerous paragraphs of the complaint in the record appendix. It's repeatedly stated that she says how important that is. Paragraph 27, she clearly states that the inclusion of the furniture is an important element.
But it just says of the furniture. Is that the most specific that your complaint gets?
So paragraph 26, where she specifically tells the broker that she wants the furniture that's currently in the house included as part of the sale. So the house was—
That's what your client told the defendant.
Yes, and that was yes, and those were the terms that she had expressed repeatedly to the defendant about how important it was to have this property in move-in ready condition.
And what paragraph shows us that there was a meeting of the minds that it was to be that furniture in the complaint?
I believe it's fairly well stated in terms of the furniture that was in place at the time of the showings was the furniture that she had bargained for to be in place.
So, for example, at paragraph 34, you say that your client asked him, the defendant, to confirm more than once that the furniture was included in the sale. It was important. Each time she asked, he confirmed the furniture was included.
Yes.
Okay.
Yes.
Are there any writings to that effect that were attached as exhibits to the complaint?
Not to the complaint, Your Honor. There certainly through discovery, there are going to be probably discussions amongst—
Right, but we're not there yet. I want to know what the judge had before her.
Sure. So thank you, Your Honor. So again, the issue is the complaint adequately pleads the several acts in practices under 93A. We talked about the misrepresentation of the seller's intentions regarding the property, misrepresenting to LOHEAC the contents of the contract to purchase.
I'm trying to figure out paragraph 31.
Sure.
Says that the brokers agreed that the furniture would be included. So is the mistake here not including that term in the mistake, whatever, the wrongdoing or whatever you're alleging by the broker here? Is it the failure to include that provision in the, not the P&S, the contract for purchase? Or is your position that he was lying to you your client when he said, we've agreed and the furniture is included?
Well, Your Honor, he represented to our client that that was the deal. And so it is our, upon information and belief that those were the terms that were agreed to. Now, it is also pled in the.
Well, then what's your beef with the broker? If he got the terms you wanted, but the seller failed to honor them, why are you suing the broker?
Because the broker took it upon himself to draft the contract to purchase to memorialize those terms, and he represented to our client that he would include those terms in the contract, and those terms were not in the contract. So he represented.
No, but presumably if they were what you had actually agreed to 13 days before the P&S was supposed to be signed, and you went to now maybe this doesn't matter, you went to the seller and said, your broker and my broker agreed to this. I don't know why it's not in this. Let's put it in the P&S.
But Your Honor, that is what's stated in the contract, is that the seller pointed out that the contract that the parties had signed, that they were not, the seller refused to go ahead with that in the P&S because they said that the contract to purchase stated what it stated, and they did not, they whether they changed their mind, whether there's a misrepresentation on their end, you know, that's something discovery would yield. But
let me ask you this. You have to show what? Intentional act or reckless act? What counts for 93A?
93A, Your Honor, it's based on the totality of the circumstances. And so an unfair or deceptive act need be shown. And
can a negligent act be unfair and deceptive?
If it is a negligent misrepresentation in the course of business, which one of our counts has pled, yes, Your Honor, the case law specifically says that that claim can also constitute a 93A claim, yes.
Negligence can be, right? So your story is this broker went the extra mile and got the thing that you wanted and then failed to put it in your contract. Maybe, I mean, there'd be no reason, right? It doesn't help him get a commission or anything to fail to put a term that he's already had agreed to. So he failed to put it in, presumably negligently, but I don't know. And as a consequence, you didn't get the furniture, you only got the house. That's your argument.
Well, we don't know why he didn't include that in, Your Honor.
Okay, but it can't be, we take the complaint as true. So the other side agreed to include the furniture and then your broker didn't put it in. That wouldn't be of advantage to him, right? It wouldn't help him at all.
Your Honor, 93A doesn't require showing that
I understand that. I'm just trying to figure out what your claim is. Now, let me ask you this. If you were unhappy with the failure to put the furniture term in, and you had said to the opposing side, you haven't put the furniture in, and they said, well, we're not going to now. Do you agree that you could have walked away? Your client could have.
Your Honor, certainly everyone can make choices, but in terms of the loss of the transaction, they would have lost that deal that they
no longer had that deal, right?
They didn't have it because of the broker. Yes, Your Honor. The broker failed to provide the bargain that they had bargained for.
If indeed it turns out at trial that they never agreed, you think they did and it was a mistake, so maybe this is a foolish question. But if it turns out they never agreed even, and so in fact, the contract for purchase accurately depicted what the parties had agreed to, what the brokers had agreed to, do you agree that your loss, and this is enough, I think, but do you agree that your loss was at least the $1,000 deposit?
Your Honor, if it is shown that that was not in fact the agreement and that the broker lied to my client directly, I certainly believe that that would more than satisfy the 93A complaint. And in that instance, it would appear that the damages, one would argue, would be limited to 1,000, but her not knowing that he had lied to her, arguably you could still claim that her out of pocket. I think we would still seek
Yeah,
that.
I just didn't see, I didn't understand. You keep saying they lost the deal, they lost the deal. Now I guess I do understand. I thought there was no deal. Look at the, right? Like you lost a deal that was never offered to you, but your position is it was offered and this negligent failure. So you're going to have to prove either, assuming we can't say as a matter of law that negligence isn't enough for 93A, obviously we'll look at that. We will have to, you will have to prove that his failure to include this term, even though he may not have benefited from it, was an unfair and deceptive act or practice.
Your Honor, we also pled that he specifically represented that the terms that she had bargained for were in this contract, and that he's, whether he intentionally or negligently represented that is, negligent misrepresentation of a material fact in a commercial transaction, that would satisfy 93A, Your Honor.
Interesting. Okay.
I see there's minimal time. I do want to address, there's a few other sort of procedural challenges to our appeal, which I have addressed fairly substantially in our reply, but if Your Honors have any questions on those.
This is the demand letter question and the timeliness of the notice of appeal question.
Yes, Your Honor, Chapter 93A, Section 11 never requires a pre-suit demand. The motion for reconsideration was served within 10 days of the judgment, which certainly tolls the period for the notice of appeal. We've addressed these all in our reply. The other thing, Your Honor, we also have a fiduciary duty claim, and that also can satisfy a 93A count. He had a fiduciary duty acting as her expert who was engaged to guide her in this process to act pursuant to her wishes. So, Your Honor, it's not just a negligence issue, it's a misrepresentation and it's a breach of fiduciary duty and all the other complaints. And I thank you for your time and for your consideration.
Thank you very much. No further questions? I see none. Interesting case, interesting argument. We will hear from Attorney Bagley.
Thank you very much. Good morning, Justices. Martha Bagley on behalf of the appellee, Attleboro. May it please the court. Judge Fahey's decision back in September of 2019, excuse me, was to allow the claims, but not the 93A. To capture what Judge Fahey said was that the plaintiff signed the offer to purchase. On the four corners of the document, there is no reference to the furniture. This document was sent from my client to the buyer. She had a couple of weeks, she had 24 hours to sign, but a couple of weeks between that and her hiring of counsel and entering the purchase and sale agreement. What I'd like the court to focus on is the contract to purchase. In it, it's just the offer is described, the purchase and sale agreement date is set, the closing date is set, who will hold the escrow is set, contingencies in paragraph 6 are provided for, none are listed. There's a mortgage contingency, inspection contingencies, and then there are representations and acknowledgements. And in that paragraph, paragraph 7, which is 2 paragraphs above plaintiff's signature, it says that there were no other agreements part of this. And I think Judge Fahey was right on the money when she said that the signing of the offer was contributory negligence.
So what?
So
what? We're talking about standing to pursue a 93A claim. Maybe you have some defense. I don't know how that works. But the question is, was there any injury? You're looking at that document. I don't know that the judge ever held that it was contributory negligence. As I read, held that. I
Yes.
read her holding to be that Ms. LOHEAC knew that the furniture was not included, yet went through with the P&S and therefore was not injured. That's the only holding I see from the court below. So do you say that contributory negligence extinguishes 93A claims?
No, Your Honor.
All right, so the question is, can this go forward? You may win on a defense, or maybe it wasn't unfair and deceptive once we probe why it happened. But your sister says that your client told her client, we've agreed to this, she believes that that's true, then failed to put in the document that you've described this additional term with current furnishings in it, and misrepresented to her client that the furnishings were included in the document, although maybe there's contributory negligence, I don't know. And I don't understand why that doesn't state a claim.
For a 93A action,
Yes.
Your Honor, it has to rise to a higher level. This is not a common tort.
How
Every
high,
breach-
well, what does that mean? Higher on what dimension?
Higher on my client's actions is unfair or deceptive. He made a mistake. That
Well, I
could
don't know
have been
anything about,
corrected.
that seems like that's a jury question. Is it a mistake? Is it intentional? What was going on that led him to repeatedly say this term was in here when it wasn't? I have no idea. But she says she was deceived into signing this thing. Maybe it was only through negligence, and then I guess you'll win on the merits. But this was kicked out as a matter of standing. No injury because she didn't have to go forward with the purchase.
Which is one way, Your Honor, but it doesn't.
It's not
rise-
one way, because I think you'll agree with me, because you almost say this in your brief. If she hadn't gone forward, she'd have lost the $1,000, right?
Yes.
Okay, so her injury, in your view, maybe is limited to $1,000 if she proves everything else, but that's injury. Why can't she bring a 93A claim? You guys can fight about whether the injury was 1,000 or 40,000, or maybe you'll win at trial and it won't be found to be unfair and deceptive.
In the practice of business, in 93A was put in place and looks at FCC and federal mandates as its guidance, Your Honor. It was put in place to protect consumers. It does not negate the consumer's responsibility to read a document they're signing.
So you want us to say, as a matter of law, a misrepresentation about what's in a document that can be resolved by reading the document can't be an unfair and deceptive act or practice?
Yes,
Huh.
yes. Because if we
But
don't,
isn't
how
that
do we?
a
Have you ever been, yeah, go ahead. Judge, please.
Isn't that a jury question? You may very well prevail on the merits, but we're not there yet.
I don't believe that a potentially missed phrase in a 2-page contract rises to the level of rascality discussed in the 93A level of
I
cases.
guess it depends what the phrase is. So for example, if I were signing a mortgage and they put in, and I didn't notice it, that the rate was adjustable and would go up to prime plus 18 in 6 months, and I signed it because it was put in front of me, even though it's only 2 pages, chances are that might be an unfair and deceptive act, right?
Not if I had the opportunity as a consumer in a business, Your Honor. She bought
Yeah,
this
I know
as an
it's a business.
investment to read the document and
Have
make
you
it.
have you ever been to a closing?
Yes, Your Honor, a number of them.
How many documents would you say each side, the purchaser signed or the mortgagee signed?
Oh, dozens.
Okay, do you think they read them?
It's not up to me to be concerned about that.
Well,
What
it
I'm
is up to
concerned-
you, because if people don't usually read them, then being told something about them might be unfair and deceptive. Whereas if they're things that everyone reads, maybe it wouldn't be.
We have,
That's sort
she
of a
had the
fact question.
opportunity to read the document. My sister has said repeatedly in her 15 minutes that my client said this and my client said that.
Mhm.
The document was in front of her to sign. If she saw that the language wasn't in it, her opportunity was either not to sign the document or insist that those provisions go in and continue negotiations.
You've never
She
seen a
failed to do
case where
that.
a lawyer and says to their client, yeah, here, I did exactly what you said. It's this will or whatever, and the client signs it. And then we wind up in 30 years of litigation because it doesn't say what the lawyer said it said. You've never seen a case like that where people sign documents that the content of which have been misrepresented to them? I mean,
No, Your Honor, when I have a client and I do a closing, I go through the documents with the client.
I've been
If I
doing
have a
closing
matter-
too.
if
And
I have
you say you do, but do you go through every paragraph of the note? I very much doubt it.
I had to because my husband demanded it.
Well, it depends when, right? Depends what the closing is, and depends on what people. It seems like we see your point, I guess, but it seems like a fact question to me.
How can we have contracts if you're not held to what we sign?
That's why we
written
have
in
lawyers.
English.
That's why we have lawyers. People hire lawyers to read the contracts because they don't know what to make of them.
Well, that's a great point.
That's our business model. Is there are things that are too complicated for lay people, so we have lawyers, or in real estate, maybe you'll win on this, but maybe we have brokers who are supposed to do the same thing.
Your Honor, if you look at the contract that we're discussing at the very top, it says binding contract. If legal advice is desired, consult a lawyer.
Well, I have
He
to say,
failed to do so.
those are fine merits arguments for why there's nothing unfair or deceptive, although I have to say, none of the five of us is probably that good of an expert on what lay people think when they look at a contract.
A lay person in the business of real estate, not just a lay
business of
person.
real estate. Look, I don't know, owning a rental property and being in the business, but even in the business of real estate, obviously, if you don't get a lawyer, you're a fool. But if your lawyer makes a mistake, it's not on you.
No, but this wasn't an attorney, and should he be held to the level of such? No, he should not.
I don't know what the levels. I guess you'll be fighting about that at trial.
But
Can I just ask
yes,
two
Your Honor.
procedural questions? You agree with your sister that a demand letter was not required?
Yes.
Okay. And having read your sister's brief and reply brief, do you agree that the notice of appeal was timely?
No, I do
Why not?
Because she could have done both the notice of appeal and a motion for reconsideration. And
Doesn't the motion for reconsideration toll it?
not under the rules of the court, under Rule 4C2, I believe. I apologize, 4A of your court. It is not one of the state proceedings.
Whoa.
I do not believe.
Under the rules of appellate procedure or the rules of the appeals court?
The rules of appellate procedure, Your Honor.
Hold on. Rule 4, you're saying?
Yes.
And this is under, you're saying 4?
4A.
4A.
The time for filing notice was told because of the motion for reconsideration filed on September 23rd, which was within 10 days of the judgment on September 13th. That's Mass Rap 4a. The notice was then timely when it was filed on November 20th because it was less than 30 days after the order entered that denied the motion for reconsideration.
Then yes, Your Honor, I appreciate your help, Justice Blake. You've helped me throughout my career.
Can I ask you, do you agree that because there was initially this issue about the jurisdictional limits, that if we send it back, it's going back to the district court, not the superior court because of the jurisdictional change?
Yes.
Well, has it been filed in the district court?
I do not believe it has, no.
I think the judge remanded the rest of it to the district court.
Mhm. Yes.
Well, we could remand it to the court it came to us from with instructions that if
Right.
the jurisdictional amount ruling stands, then it should be sent back to the, with the rest of the case or whatever, if we were to reverse, which of course, we've not discussed among ourselves yet.
Any further questions, or may I conclude? I may conclude. I would respectfully request that the court affirm the lower court's decision and deny the 93A claims for the reasons set forth in my brief and at oral argument. And I thank you for your time and a rousing discussion.
Thank you very much for an excellent argument, both of you. It's a very interesting case.
Thank you very much.
It is submitted.
Thank you, Your Honors.
Thanks.
Jake,
Yes.
are we live and recording?
1 second, make sure. Yes, we are live and recording.
Thank you very much. Good afternoon, everybody. Welcome to the Appeals Court. I am Justice Rubin. I'm joined today by Justices Blake and Lemire. The next case we'll be hearing is number 20-635, Fisher versus Fisher. The rules for argument by teleconference, which we are engaging in due to the ongoing pandemic, are the same as the rules for argument in our courtroom, which is to say 15 minutes per side and no rebuttal. And we will hear first from Attorney Fryer.
Thank you, Your Honor, and may it please the court. First thing I would note is that the one thing the land court said in its decision, which I agree with, is that there's no basis for summary judgment on the merits because there are material facts in dispute.
Can you hold on a second? A timer is supposed to appear so that we know what's going on, but it has not appeared. There we are. Proceed. Sorry about interrupting you. I know it makes it hard.
Thank you, Your Honor.
So where does it say that in the judgment?
Say it again?
Where does it say that in the judgment?
It says that in his decision. I believe it's
I have it in front of me. Can you tell me specifically? Because I don't see that.
Yes, it's it says at the top of page 7 of the summary judgment decision, there are plentiful factual disputes on this issue, and it would therefore be inappropriate to decide the merits of this claim at the summary judgment stage.
Is this on the question of standing, though?
No, this is on the question of undue influence.
Okay, that's fine. Let's see if we can address standing, though.
Yes, well, that's what where I was headed, Your Honor.
Okay.
Obviously, that to me, that's the big issue here. And so, first of all, I think that there is a claim here. The claim of undue influence and claim of breach of fiduciary duty, those are claims that survive the death of the decedent. And therefore, those claims are an asset of the estate, and it's appropriate and permissible for a co-PR of the estate to pursue those claims.
Can you explain to me, I find this much more complicated maybe than it is, so that may be my shortcoming. Okay, so Ardell Fisher had a tenancy by the entirety. Tell me how that was injured when it was taken away from her, or when the whole house was taken away from both of them. How does this work?
So what happened was that through undue influence, assuming the facts are accepted as true, through undue influence, title was conveyed out of the tenancy by the entirety to the son Cameron.
Okay, and so while she was alive, she could have brought a suit.
Correct.
Would she have claimed money damages or merely sought rescission?
Well, there could have been money damages, but the primary relief would be rescission.
What money damages might there have been?
Well, there were expenses incurred. There was an attorney involved representing all three parties who had to be paid legal fees for this transaction.
Have you sought any of that in this proceeding before us? Have you sought any money damages?
Yes, there is a claim for money damages under the claim for breach of fiduciary duty. And it was a breach of fiduciary duty because Cameron held a power of attorney at the time of this transaction and used it to implement the transaction, and did it in a way that was contrary to what was stated in the documents as the intent of the parties, which was to have title held jointly between him and his father.
I saw no discussion of money damages in your briefing.
I did not, Your Honor. I did not address.
Well, but money damages might well go to the estate.
That's correct.
Right? Whereas injunctive relief, it's like a hall of mirrors. It's incomprehensible.
Oh, we're not seeking injunctive relief, Your Honor.
Well, isn't rescission in the nature of an injunction?
I don't believe so. What it does is it unwinds the transaction and puts title back to where it used to be.
But, well, it's not money damages, so it must be an equitable remedy rescission? Well, I mean...
I don't know if rescission counts as an equitable remedy.
But I don't understand how it helps that part. I don't understand how it helps the estate.
I think you're correct, Your Honor. And if I'd had your wise counsel in drafting the brief, I would have raised the argument. But I certainly think that's a valid point, that there are money damages that have been claimed. To the extent there is a recovery associated with a finding of undue influence, then that would be a recovery for the estate.
The transfer took place in 2003, right?
Correct.
And then mom dies in 2013 and dad dies in 2016, right?
Correct. Yes.
And then your client brings a claim in 2017.
Correct.
And to me, the nub of the judge's ruling about standing is that mom had no right to the property upon her death, and therefore there's no claim. So can you speak to that point? Do you have a case on that? What is your best argument that the judge made an error in that conclusion?
Well, first of all, Your Honor, I would point out, I will answer your question. I'll point out that the land court in its decision did not cite any authority, and I'm not aware of any, neither has the opposing counsel cited any authority for the proposition that there must be a recovery of an asset that goes into the probate estate in order for there to be a viable claim and to have standing. What's happening
I'm trying
here?
to figure out, all right, let's pretend that this is not against a brother and a personal representative and so on. And a woman dies and she has a tenancy by the entirety, but she predeceases her husband. And well, this is an impossible, this is why I'm in a hall of mirrors. Of course, if she alone had conveyed her tenancy by the entirety, it would be ineffective after her death. The property, the right of survivorship is not alienable. So it's indestructible, and whoever had it would lose it at the moment of her death. In this case, because she also consented to the husband's sale of his interest, the whole house went. So it's hard to imagine, but let's just imagine it. So she did something. She sold her tenancy by the entirety, and now she dies. And it's clear that the husband, who's still alive, could bring a suit. Statute of limitations we may have to talk about, but the husband could bring a suit. Where's my house? I don't have my house. Oh, my wife sold it in a way that injured me. So he could bring suit. The estate might ordinarily inherit the claim, but now it's got some people, heirs, who are like, I'd like you, executor or personal representative, get all the money together and I'd like mine. And he says, no. First, I have to spend all of that money on a lawyer in order to get a piece of property that you aren't going to get. It's going to go to the husband, and he doesn't care. He won't bring a suit. So I'm doing it for him to make sure your late mother's wishes are fulfilled. Wouldn't the heir maybe be able to stop the executor from doing that, since no money would accrue to the estate?
I don't believe, well, here, Your Honor, here's the benefit to the the co-PR, my client, bringing the suit. His parents' wishes as evidenced by the 1999 acquisition and by the wills that they executed, was first of all for the surviving spouse to have title to the property, and then under that spouse's will for the assets, including this property, to be divided equally between the two sons. Even though setting aside the conveyance does not put any asset directly into the mother's estate, what it does do is affect the wishes of the mother that the property pass as the two of them had intended. And it happens that the
But
mother.
then only the dad then has any standing to raise that claim before his death and after her death.
I don't believe so, Your Honor. I think that because it's a claim that the mother had and
So
could
you
have brought.
think before dad died, your client could bring a claim?
I'm not. Yeah. Yes. Absolutely.
Okay,
If
and
my
he
client
didn't, right?
If he didn't know about the conveyance until after his father died, if he had known about it before, he would have brought the claim on behalf of the mother's estate, just as he has done now. He did so.
Wasn't he the personal representative before the father died?
I'm sorry?
Wasn't he the personal representative before the father died?
Of the mother's estate.
Yeah, so how come he didn't know she had conveyed the real property? Didn't he have to figure out what her assets were?
Marshal the assets and prepare an inventory?
No, it was Cameron's. Cameron was a co-PR. Cameron was the one who lived with his parents. My client lived halfway across the country.
Okay, but wasn't he on at least constructive notice? He's a personal representative.
I don't think there's any constructive notice of the conveyance, no.
Well, was he appointed as the co-PR by the probate court?
Yes.
So then he has a fiduciary obligation to the estate that includes marshaling the assets, not wasting assets, preparing an accounting, preparing an inventory. His brother has that same obligation.
Right.
It doesn't matter where he lives. If he's appointed and a probate court judge saw fit to appoint him, notwithstanding his residential address, he has fiduciary obligations. And there's a 3-year gap between mom's death and dad's death. And he sat on his rights.
He may have had those duties, but there's no claim against him for breach of those duties.
No, because it's your lawsuit, right? It's your lawsuit.
Yes. What I'd like to do, though, is also move on to the fact that you mentioned earlier the claim should be brought by the father's estate. And
his personal representative, after investigating, declined to bring that suit, and he has an obligation as a fiduciary not to waste the estate assets. And in his independent judgment, there was no action to be brought.
He didn't say there was no action. What he told the court was it was a difficult decision.
And he declined it.
But in a case like this, where the PR of an estate declines to bring a claim, there is a statutory right of my client as a beneficiary under Chapter 230, Section 5, to bring the claim for the benefit of the estate.
But it's of dad's estate.
Of the father's estate.
Yes.
Right.
Yes.
So
why don't you do that?
My client attempted to resolve this problem by moving to amend the complaint to add Mr. Rapp as co-PR.
As a defendant.
As a Rule 19 party. And it's a defendant because since they're not voluntarily joining, it doesn't matter.
He didn't move under 230 Section 5 as a beneficiary of the father's estate, did he? To sue, right? I mean, if the executor isn't, or personal representative isn't doing it right, the heir has some rights, right?
When this issue was first raised, Your Honor, and the judge raised the question of whether Mr. Rapp needed to be a party, I filed the motion to add him as a party, and the judge denied the motion, concluding that it was unnecessary for him to be a party. And then what happened was, on the summary judgment, the judge says, wait a minute, I think this is still a problem, and therefore granted summary judgment on the ground that he was not a party, even though we had tried to make him a party.
That's not quite right. Saying he's not a party is different from saying he didn't bring a suit. That's right. I mean, the question has really nothing to do with the father's estate. This is not a suit by the father's estate or by your client as a beneficiary of the father's estate. The only question I think we have is about whether the mother's estate has standing. Let me ask you one other question, although I want to give the other judges some time, and this is very complicated. If I agree with you that the fact that the other personal representative doesn't consent can't stop this suit, because, or maybe as a beneficiary, he could bring this, I have no idea, but can't stop this suit if they're the one accused of wrongdoing, like in a closely held corporation where you can bring a derivative action or whatever. What would the procedure be for one co-personal representative to bring a suit without the other? Would you have to remove the other first? Would you have to go to probate and family court? What's supposed to happen?
Under the Uniform Probate Code, it is permissible for a single co-PR to bring suit if it's necessary because of emergency circumstances, which is exactly what we have.
It's not an emergency, it's a conflict.
It was an emergency because the property was about to be sold, and there was no time to go to probate court and try to have the co-PR removed. But also, there was the statutory right under Chapter 230, Section 5.
But you got to stay, right, through a lis pendens or something?
Yes.
All right, so then why didn't you go to probate court and get the other personal representative removed?
Or file a petition for instructions?
Because this issue was not raised at that point. There was a motion to dismiss that was denied because there were viable claims that were asserted. And so there was no notice to us that the court was going to consider this improper. It wasn't raised by the other side. And as far as we knew, everything was fine until the summary judgment was raised. So we were had no notice that this was going to be a problem, if I may finish answering your question.
Sure.
And so we could have raised it if we had known, but my client could have used Chapter 230, Section 5, both as an heir of the mother's estate, if Cameron did not want to join, as he obviously didn't want to join in suing himself, but also as an heir of the father's estate to bring we could have amended the complaint, and I sought leave to amend the complaint when it became apparent that the judge was granting the summary judgment, and because it's exactly the substance of the claim is the same, and it's just a matter of
we have your argument in your brief. Your time has expired, although if there are other questions, this is very complex. None, really? All right. Thank you very much. We understand your argument, Attorney Fryer, and we understand your brief.
Thank you.
It's an interesting and I'm afraid very complicated case, at least for me. Attorney Curran.
Thank you, Your Honor. I want to sort of just address quickly some of the things that you just covered and then go into the other issues. My brother stated that the judge in the land court had said that that this case was not resolved on substantive matters, but that's not exactly true because he did find the breach of fiduciary duty on substantive matters, and I'll get into that in a moment as well. The answer to your question, Justice Rubin, is that what Graham could have done as co-personal representative was to go to the probate court in the case that was already established, the estate of Mom, and bring a petition to remove his brother, and at the same time ask for a preliminary injunction stopping him from doing what he was doing. He didn't do that. He jumped over that step and brought it on his own. And I have this in my brief, but the statute does say, not only does the statute say that you have to work together, Ardell's will said you have to work together. So in terms of this standing, the lower court was absolutely right. There are several other claims, and I think I just want to quickly go into the breach of fiduciary duty, which the
before you get there, Attorney Curran, when Mom died, the property was held T by E, so it, as a matter of law, went to Dad.
No. When Mom died, the property had been already
transferred to Cameron. Okay.
2003, Your Honor.
And so
10 years before.
So what interest, if any, did Ardell and or her estate have when she passed in 2013 in that real estate?
None.
Wait a minute. Before she died, if she had believed in good faith that she had been unduly influenced to give up her tenancy by the entirety, you agree that she could have brought a suit?
She could have brought a suit during her lifetime. That is correct.
Okay, now, and do you think that that claim survives death, an undue influence claim?
With this case, it does not, Your Honor. The tenants by the entirety means that at the moment she died, at the moment she took her last breath, if they still owned that property, it would have gone to Donald Fisher. So at the moment of death, her tenancy by the entirety does not go into the estate.
I didn't ask if the estate owned it. I asked if the claim survived.
I don't think the claim survives for her. I think the claim, if there was one, is then only the claim of Donald.
So if 6 months before her death, she had filed a claim for undue influence and then passed away 6 months later, your position is that claim would have had to be dismissed because the prayer or what they were seeking would have been the tenancy by the entirety, which would have terminated on her death anyway.
That's an interesting question, Your Honor, and I'm not sure. My guess would be, and it's just.
Well, I mean, that's what Justice Rubin was saying. If she had the claim prior to her death, so I'm just suggesting she actually did it prior to her death.
Right. So if it was a pending claim,
does the estate pursue the claim at that point, or is it terminated?
That's an interesting question, but I think her tenancy by the entirety terminates. So more than likely the claim would terminate, but Donald would still have had the claim.
So even if there was an undue influence claim, you would rescind it back to their T by E status, and then upon her death, it would have passed to husband.
Correct.
So it's even if.
But Attorney Fryer suggests he could have been suing as well for the rescission, but also for like attorney's fees and costs of the action. So would that also go away?
No, anything related to the bringing the property back. So the undue influence is related to 2003 when they signed this deed, which, as the court found, if you look at that breach of fiduciary duty claim, the court found that the parents were well, the parents were on their own, the parents were independent, they were healthy.
How can a court find that without a trial? I don't know what that means.
Because based on the evidence that was the undisputed evidence, in fact,
this is motion to dismiss.
This was a motion for summary judgment.
Summary judgment, okay.
It was a motion for summary judgment, so there were lots of documents and testimony put in there. And Graham, in his testimony, admits that in 2003, they were able to get out of the house by themselves.
Okay, but I mean, we'll look, but I find it hard to believe there's not a disputed fact about that somewhere in what's in the record.
Your Honor, that's what's interesting. That's what's very interesting.
Is the complaint verified?
The complaint is verified, Your Honor.
All right, so, all right, we'll look.
And what, Your Honor, now that you brought that up, I would like you to focus on my statement of undisputed facts, which starts on RA 68, and their response on RA 353. I have never seen such a response in the many years.
What do they say?
So all I'm talking about, Your Honor, is his answers throughout the response to defendant's statement of undisputed facts is he either says it's not disputed, or he says it's disputed because the Cameron is not a credible witness, and the evidence is not admissible. That's his argument. There's no other, he brings forth no witnesses, no other information, no documentary information.
All right, so, but let me ask you this. if the claim that the hypothetical claim Justice Lemire talks about, where the mother brought suit before dying, seeking rescission and $8,000 that she had paid to a lawyer, because when she was unduly influenced, it included that she had to pay a lawyer to put the paperwork together. And then she died. You agree the money damages part would survive, and it would be a claim of the estate.
If the mom had spent money, which the record does not support, by the way, because Cameron was the one that paid the legal fees.
Okay.
But that perhaps could be, but again, we're talking, there's a statute of limitations problem.
Okay, but I'm not asking about that. I'm just trying to figure out standing. And then the question I have next, perhaps obviously, is if the estate would have standing to bring the money damages part of it. Are you just saying that with respect to rescission, it's moot? That aspect of that case would become moot?
The ownership in the property, which was the main claim for relief that was being brought here, is what the judge was focusing on, because this was his main complaint was this 2003 transfer was not, he had no standing for that. I would say to you, Your Honor, he was raising other issues in that land court decision, and the land court kept saying, I don't have jurisdiction over this. He kept raising jewelry, and the judge kept saying, and he says this in his decision, I don't have jurisdiction over jewelry, and go back to the probate court for that. That has nothing to do with me. So he brought this case in land court talking about a piece of property. So I think that's where.
But does the land court have jurisdiction over money damages?
Not unrelated to property, Your Honor. I
understand, but so if it's related, is it ancillary jurisdiction or is it within their? Let's say the only thing that had happened was that she had wrongly had to spend money. At the end of the day, she wound up keeping the property because when she finally hired this lawyer she didn't want to hire, the lawyer said, do not sign this. And she had gone like, well, I'm not gonna, but I spent $8,000 on you and it's because of Cam's jerkiness. Can that be brought in the land court?
No, Your Honor. That's money damages, and I do not believe that that can be brought in the land court.
Just so it's
there
clear,
was a
though,
perfect, I'm sorry, go ahead.
the prayer for relief of the complaint is for rescission of the deed and rescinding the transfer of other assets. It does not seek damages of the cost of the transfer originally.
That's my understanding, Your Honor.
So maybe it's a moot issue as to whether or not that survives. Because it was rescission that they sought.
Right. If I may, I've got a couple more minutes. I would just like to again point out that breach of fiduciary duty, which he substantively found that Cameron did not have any fiduciary obligation to his parents. This was a mutually beneficial arrangement that they made. And they had lived together in Vancouver, and Cameron had helped pay, and then they had purchased this piece of property. And when the judge looked at those facts and what he stated as findings of fact in the summary judgment motion, those same standings could apply to the undue influence case. It's the same thing.
But he didn't go, the judge did not go there and instead threw it out on standing. You're asking us to adopt those findings and make a summary judgment decision here.
That's correct, Your Honor, because it's the same standard that would apply. One of the things that was argued below is that undue influence, the first factor in undue influence is whether or not there was a that a transaction had taken place that was not appropriate. All right. And in this case, that is not true. The parties made a decision to transfer the house to their son, the parents, and they continued to live there. He made all the payments from 2004 until today. He's still paying for this house. Prior to that, he had made some payments. My brother's brief goes on and on about, well, we don't have a lot of documents. We don't have a lot of documents, Your Honors, because this was back in 1999. So, right, they don't have a lot of documents between 1999 and 2004. We do have before you a few documents showing Cam made some payments. But we absolutely have from 2004 until today, the record just shows through 2018, we have Cameron making all of the payments on this house. These people lived in this house. And by the way, even in 2003, they were traveling on their own. When mom died, she traveled to see Graham. Mom and dad together traveled, and she had a tragic fall and died while with Graham. And so they were.
Can we go? I'm sorry to do this, but in light of the time, if we could go back to standing for a moment. If the 2003 conveyance was valid, then Cam owned the property at her death and there's no claim.
That's correct.
If the conveyance is invalid, then Donald owned the property at Ardell's death and there's still no claim. That's by Graham. That's your argument, right?
Correct.
That's what it boils down to.
Correct.
And we don't reach the other issues if the case is, hypothetically, if the case is affirmed on the standing ground.
Well, I think you can reach the other issue because.
Why would you want us to do that?
The only other issue I would like you to address, as we just talked about, is that where the court found in the breach of fiduciary duty claim, which was.
Why should we reach that? If there's no standing, there's no jurisdiction.
There's no jurisdiction in terms of this, in terms of him as co-personal representative. That's correct. That's correct.
And the other issues would go to the probate court, right? In the estate actions.
Right. And he's already brought that case.
Right.
In Graham's, in Donald's estate, and Judge Daniels has already dismissed that case.
But you're not suggesting. Are you suggesting we find standing and then go the extra step and find summary judgment?
No, Your Honor. No, Your Honor. I am just saying that on the record that was before the land court, he dismissed the breach of fiduciary duty. He could have dismissed the undue influence substantively on the same grounds. That's all.
Right, but you get the same result on standing.
Correct.
Yeah.
So only if we were going to find standing would you want us to go to the substantive.
Well, I certainly don't want you to undo the standing.
All right.
And if I could just point out quickly, I did ask for attorney fees both below and here. This is really a matter of fighting brother.
We have your brief on that point. Excellent argument, Attorney Curran.
Thank
Attorney
you.
Fryer, both of you. Your time has expired and the case is submitted.
Thank you so much.
Thank you.